Hey guys, all right. Welcome to our very first live on Courtroom Confidential. I got to tell you, I think of myself as as a man of average intelligence. I mean, I was a lawyer. I managed to get myself through law school. I managed to pass the bar. I've been practicing for a little bit of time since then, but I have been flummoxed in trying to figure out all the intricacies of doing a live stream. And so this was a little nerve-wracking. I'm not going to lie, get this thing all up and going, but I really appreciate everyone being here and for your patience and for being along for the ride on this brand new adventure of all the new things that we are trying to uh, we are trying to bring you here on Courtroom Confidential. And hello to Future, one of our brand new members here on Courtroom Confidential. Um, Let me say this: we've got the live stream for the Karen Reed hearing that's going to be starting in any minute now. We will keep an eye on that, and as soon as that looks like they're going to start to go into court, we will hop in there right away. But in the interim, to begin with, I just wanted to jump on here to tell you guys about some things that we've been working on behind the scenes. We started this project of Courtroom Confidential just a few months ago, and so far it's been absolutely a roller coaster ride and really fun and really I gotta say just so encouraging to get the feedback from so many people and enthusiasm from everyone watching. And I can see you all in the comments now, and I thank you all for being here. We are a small but mighty group, and we hope to make that grow. And in furtherance of those efforts, we've been working very hard behind the scenes to try to bring you more and more exciting new content on this show. And I wanted to talk to you about some of that today. The first thing in making this more interactive, in being able to bring you all more content, in me trying to steal away more time from my day job and be on here doing live streams and more videos, we are very excited to announce this morning that Courtroom Confidential now has memberships. And this comes with a lot of new perks and new benefits and new work that we're all going to be doing for you guys. So I wanted to walk you through some of what we plan on offering. Hopefully you will be excited to join and realize some of the benefits of all of that. And then we're going to talk about the hearing and what to expect. And if you guys have comments or questions on the membership or the hearing coming up, please let me know. And I will try to get to as many of those as I can. And again, I appreciate your patience with all of me on this. I feel like I'm flying a plane with the amount of things that I have to keep my eyes on to try to make sure that I'm keeping up with everything. But okay. The Courtroom Confidential membership, we're going to offer 4 tiers, essentially. And I'll start going through those now. The first is what you'll see there. If you click on join, first of all, you'll see my face, which you guys are probably getting sick of at this point, talking to you about the membership, what we plan on offering. But the first level of membership is our crew member that comes along with loyalty badges, custom emojis, priority replies on comments. We're going to start doing members only polls and members only live chats so that when you go on and you're watching a live stream like this, there will be a members only section so you guys can all chat with each other. Moving on up to the classified crew. And I hope you guys appreciate the cleverness that we got to with the names that we chose for all of these levels. We've got crew member, classified member, top secret member, and for your eyes only member. Believe me, when my wife and I came up with those names, we felt it was a real light bulb moment for us. So the classified crew member includes members only shout outs, members only live streams. We're going to try to start offering that live streams for members only. And then behind the scenes photos and status updates. So if you go on the community page of our YouTube channel, you're going to start to see a whole bunch more of us just sharing our lives and who we are and behind the scenes. And I hope that you guys will find that interesting as we continue to kind of pull back the curtain. Then the top secret crew member. Now we're talking discount on merchandise, guys. And if you haven't noticed, I'm wearing our first brand new Courtroom Confidential shirt, and I will be taking sips out of my brand new Courtroom Confidential mug. Again, still a work in progress, but we're going to be offering all these things on the store. And this membership will include a discounted 10% discount on that merchandise. So please check all of the new offerings that we're going to have on the merchandise store. Top Secret also includes early access to videos, early access to new merch, and exclusive member merch, which we're going to try to figure out what that is. But I think it's going to be some sort of really awesome, kind of thermos Stanley mug type thing that everybody can use. And then finally, we have the For Your Eyes Only crew member. This will include a quarterly Zoom call, which sounds like it's going to be a blast to actually interact with everyone, a thank you video, and then further discounts on merchandise. So that was a mouthful. I know it's a lot to digest. I hope that you guys are excited about it. We certainly are. And it's fun. I think this is, listen, I've been an attorney for close to 20 years, and you do not get to interact with people and talk about stuff that you enjoy and stuff that you find to be fascinating this much. And then to be able to continue to offer this and have you guys give us feedback and enjoy what we're putting out. So all of that has been tremendous, and we thank you guys. And I can see that there's new members showing up. Carly Rocks, thank you so much for that. You guys are tremendous. This has really been mind-blowing to all of us that, people are actually enjoying this stuff and showing up for it. So we will, as long as you guys keep showing up for it and keep wanting it, we will continue to keep offering it to you. And if you have a chance this morning, the other thing I love hearing is where everybody is from. So seeing that, thank you to Covea 43 for the super sticker. That's another thing about all this new membership and everything. Oh, look at this. Leslie Oliver is saying hi from South Africa. And that's exactly what I was going to say. If you guys are tuning in from around the world, which is pretty amazing to watch some of this stuff that we're covering, please let us know where you're from, because that really is touching to me, just to see that this is not just a local but worldwide endeavor. So we're talking about Karen Reed this morning and the never-ending case. Let me say this up front. And hello, Mary from Virginia. Hello to Canine Kathy from Maui. Hello to Laura from Toronto. I know Alan Jackson. I don't know how many of you guys know that. I worked with Alan Jackson when I was in the DA's office. I was his law clerk forever ago. When he prosecuted the Phil Spector case, I was his law clerk. So I've known this man for 20-something years. I consider him one of my mentors. I worked with him in the DA's office for a long time. We kind of had different career paths. He was obviously on the huge and high profile cases. I was kind of a young attorney making my way in the DA's office, but we always stayed in touch. He left the office, and soon after that, I left the office to join his law firm as a defense attorney. So I've known him both as a prosecutor and defense attorney. And I will say that he is an excellent attorney. Whichever way you guys come out on this whole case, I think everybody agrees he's an excellent attorney. But what has happened in this case has been absolutely mind-blowing to me. I've just never seen it. I mean, I feel like I'm at a point in my career, and thank you so much, CJ, for becoming a new member. I feel like I'm at a point in my career where I can start to say things like, never in my career have I seen such and such. And never in my career have I seen a case end like this, where you start to get jurors who are making so much contact with the parties involved that they are, questioning what took place um, with their deliberations, and then asking, essentially, I mean, for them to essentially be asking to um, have their deliberations reopened. I mean, you never hear anything about this. Maybe jurors will reach out to say, thank you so much. I've had some jurors who say, it was a great experience to be part of a trial, but never for them to let you know that, hey, by the way, we may have missed something, which is exactly what is going on here. So I'm finding out that Court TV may be live. We're looking at law and crime. So if Kaylin, by the way, I want to introduce you guys to somebody who you're not going to actually see. Oh, there's Court TV. Okay, great. Kaylin is the absolute bedrock behind this whole thing, who makes all of this possible. She is been working with me and my wife, Tiffany, who you'll also see in the comments as T-Suze. All of this possible. And I wanted to give a huge shout out to her because we wouldn't be here without her. And if you hear me referring to Kaylin, that's what I'm talking about. And Kaylin just found out that actually Court TV has something we can actually keep our eyes on. So we'll continue to watch that. And like I said, when they start to actually make some noise there in court, we'll cut away. But what I was saying is, I've never seen anything like this, for jurors to be so involved after the fact. And I think what it's showing is something really did take place that was wrong. And we can talk all day long about how that happened. I think a lot of that had to do with the jury verdict slip that they received. I think that was entirely confusing. But now we're to the question of what's going to happen. And there's really two things I think to chat about here. One is what should happen, and the other is what will happen. Let's get to what will happen. This is my prediction before we start court. I'm keeping an eye on it. My prediction is, I don't think anything's going to happen. I think the judge is going to punt on this. I think the judge is going to deny this motion. We're not going to have any fully fleshed out hearing as to what actually took place, what these jurors were actually thinking. I don't think any jurors are going to be brought in to put on testimony. And I think the judge is going to say, this is an issue for the appellate courts and we'll see you later. So I'm glad I got that out before it looks like people are starting to hustle into court. And that, now I'm on the record as to what I think is going to happen. But what should happen, I think, is the Commonwealth should dismiss these charges. They should dismiss the two charges that the jurors are saying they were acquitting on, for a couple of reasons. One, you already know those are the weak charges in your case. You've been told that by essentially a 2-month-long mock trial. And two, those are the weakest parts of your case anyways. If you want to pursue this thing, go ahead and pursue it, and get rid of all of the mess. Oh, there's Karen Reed, looking sharp as ever. So it looks like we are going to get started soon. But I do think that the smart thing, not just from a make it all clean, make it more simple perspective, but the smart thing, thank you, K9 Catherine, for the membership. The smart thing strategically for the Commonwealth would be to dismiss these. If they really want to pursue a case against her, make your case stronger, trim it down, get to what you feel like you can actually prove. The other thing is the defense can learn from this too, folks, by the way, because one thing that these jurors are saying, they may be saying that they acquitted, but they are not saying that they believed the defense theory on the conspiracy. They're just saying that they had a problem with the intent. That's what I think it really comes down to, because it looks like they were leaning towards conviction on the driving while intoxicated, which, by the way, means that they still believe that her car made contact with his body. You guys can argue if you want all day long about whether or not you believe any of that, but I will tell you right now that the jurors, at least, were not buying the defense theory on this being a conspiracy and him being beaten inside the home and dragged outside. Good. No, that's not. And by the way, hello, Jay. This is my friend Jay from the Shaming of Jay. Wonderful channel. He has been tremendously helpful in helping me get through this whole streaming thing. And I don't think that's a dumb question at all. But where is he? I don't think he's out. I just don't think he's there for this. Maybe he sees the writing on the wall like I do, in that he feels like this is not actually going to go anywhere today. And he's saving the flight out to Boston for when the rubber's going to actually hit the road. All right. Kaylin, do you think you could bring us the volume on this? Looks like we're going into court.
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice Judge Cannone, now sitting in the Norfolk Superior Court within the Fuller County in Norfolk, Brown, New York, defendant shall be heard. Say the Commonwealth Court and see the court now in session.
Judge 22-117, the Commonwealth versus Karen Reed. So identify yourself, starting with the Commonwealth.
I'm not the Commonwealth captain.
Yeah, committee Ron Weinberg on behalf of Karen Reed, who sits to my left, and co-counsel David.
Good afternoon, Mr. Weinberg. Good afternoon, Mr. Cannone. Good afternoon, Mr. All right, Mr. Weinberg, I will hear you on your motion.
Thank you, Your Honor. May I use the podium? Thank you. Judge, there are two central issues. There's not one for amplification, there is one for recording.
If I could actually keep your voice up.
Yes, Your Honor.
I just want to make sure I hear it.
At a day like this, I'll keep my voice up.
Okay.
Thank you, Your Honor. There are two central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court, and in fact believe it will convince Mr. Lally in the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the Toohey charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to two constructions. One, that their impasse covered all three counts, and therefore would lead ineluctably to a mistrial declaration, or two, that the impasse was on one count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court, neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such a historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistry prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all three counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. The second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, T, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't denounce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory. And that makes them more trustworthy. They corroborate each other. And I contend that the voicemail left on Mr. Lally's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most, as other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media with public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that the defense didn't dispute that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I try to say, the legal framework here, the landscape is not quite as crystal clear as it is in the standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and the procedures important to inform sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I remember. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts, is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, I remember it because it was the tail end of the Warren Court. and it revolutionized criminal justice. And it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Map v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleading, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these two jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485-90, it said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, that something happened during, that the jurors had accessed the internet when they were judicially prohibited from doing so. Courts reconvene hearings, and I can test that it can be done anonymously. It doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, sorry, we authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors. Ask them whether they would read the lawyer's affidavits and affirm that they're accurate. Or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. And Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if legally you would, but to keep this private and keep this confidential, because we don't want the jurers to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence that is not, to establish a procedure consistent with McCollum, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, where there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, that she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps, through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those two charges not be re-prosecuted. So let me switch from the acquittal, its implications, to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. But here, at minimum, with 4 or 5 jurors saying, we believed her to be innocent, we believed there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the defendant, on the government, on the prosecutor to justify a mistrial. The SJC has issued multiple opinions. I'll read just a couple, because I think the burden of proof issue is central, Judge.
Okay, I just wanted to jump in here really quick too. I see some people are asking questions. Who we have here? This is Mr. Martin Weinberg, the appellate attorney that they brought in special just to argue this. I'm going to give a couple of quick thoughts and then we'll get back into it because I don't want to take a lot of time interrupting his thrilling and fascinating and at the edge of your seats arguments. But first, there's really no new revelations that he's bringing out here. If you read all of the moving papers, that he's arguing essentially what they've been arguing before. And those arguments come down to almost a public policy argument. He's essentially saying, in the interest of justice, you should do this, Your Honor. We have a situation where you're now being told that jurors either made a mistake, made an oversight, were confused, whatever way you want to go with that, Your Honor. The fact is that they acquitted her and it just simply wasn't recorded. And we should, in the interest of justice and then the interest of the Constitution and its guarantees against double jeopardy, we should put an end to this whole drama right here and spare this woman her continued torture. Blah, 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 blah. I do want to say I enjoy the ending comments where he says, I invite the prosecution to join me in this effort to dismiss these charges in the interest of justice. Oh, always a nice gesture to kind of throw down the gauntlet to the opposition and essentially paint them as non-justice seeking jerks if they don't join you in that. So that was appreciated. But the one point that he did make that I wanted to kind of pause to point to draw out was he made the point that this would essentially be no more than the court polling the jury had she not already released them. Now, while not technically true, that's a very interesting and I think strong argument. The judge could have found this out beforehand. That's not like the judge was legally precluded from finding any of this information out ahead of time. The judge could have said, hey, you guys are saying you're hung. Well, tell me, are you hung on everything? Totally appropriate question. And they could have come back and said, no, we're not. We're actually only hung on count, two. We're only hung on one of the three. On the other two counts, we found her not guilty and put an end to all of this. So he's right. If that is true, that what the jurors who have come forward are saying is to be believed, and that speaks for the entire jury, we would be in a very different place had the judge just asked some simple questions to begin with. And so when you look at it that way, it really does make it sound like, hey, he's not asking for a whole hell of a lot. He's asking for something fairly reasonable, something the judge could have done. And really now it just comes down to a timing issue. Now, it's not really a timing issue because there's a big problem in the sense that the judge has declared a mistrial. In this case, the jurisdiction over the jurors has been released. We're in a very different spot. But I thought that was at least the most interesting point that he's made in these arguments so far. So, Caitlin, if you want to restart it again, I will try to stay out of his way.
Commonwealth versus Stewart, which goes back to 1985, and is one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass. 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nickel. I have a copy of the Nickel decision because it's the one that was not referenced yet for your Honor's consideration. Nickel was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this is in fact a rule of criminal procedure, and that defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser includeds. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter, what about OUI? But this is different because we have 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justify, to ask the jury whether or not it was an impasse on all counts, or rather than just one. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology, if Your Honor, taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction. Defense counsel did. Your Honor elected to give a TUI instruction. And 4 hours later, the jury sent a second note. Unfortunately, there was no convening with counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, in Nicole, the Appeals Court in a case, Commonwealth versus Oregon, that we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised your judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria, a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor, that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, that we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy. Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. And Ms. Reed was acquitted. Bring the jurors in, Judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
Okay. I'll let you guys adjust your volume because I know you probably all had it cranked up. I think what we're going to try to do is just put the closed captioning on to get so at least everybody's able to read it, because I know that we're all having problem with the volume. I've been using my headphones just so I can hear it a little bit better. And we were thinking about going to another feed, but I think we'll just stick with this. Maybe try to go to the closed captioning. But again, I see a lot of people asking, is the judge just kind of allowing this to go on? The answer is yes. I've argued hundreds of motions in court before, and the vast majority of the time, what the judge says is, I've read your moving papers. Do you have anything to add? And a judge will let you go through and kind of summarize and touch on your strong points and let you be heard. But for a judge to allow an attorney to carry on this long of a period of time, she's doing, I think, a couple of things here. One, she's allowing him to make his record so that there can never be any question later on, if this is on appeal, whether or not they were given adequate opportunity to make their record. Yes, they absolutely are. And two, everybody's watching. Everybody is watching, as are we, and that she knows that. And she knows she can't start cutting him short. She knows that this is kind of their opportunity to have a moment, and she's going to let him have that moment. But I can almost guarantee you that the judge not only has already made her decision before she heard his arguments, she likely made her decision and has it prepared. It's something typed out. She's read the moving papers. Nothing he has said has been remarkably different from those moving papers. So she's just letting this all play out, and she'll likely do the same thing with Lally. And what he's doing, there's not a lot of case law on this. Case law is, laws are on the books, and then the courts interpret those, and those become case law. And so for situations where there isn't a specific law on it, like this, you have to look at case law. What have other courts done in the past? Because this has never happened in this exact situation before, there really isn't case law for them to concentrate on and to point out to the court. So there's an old adage in trial court that says, when you don't have the law, pound the facts. When you don't have the facts, pound the law. And when you don't have the facts or the law, pound the table. And that's the idea that you got to go with whatever strength you can possibly muster for your argument. And that's exactly what I think is happening here, is he doesn't have the law, not because he's wrong, but because it really just doesn't exist for him to present to the court. So he's essentially pounding the table when it comes to the judge and saying, Judge, please just do the right thing. Just bring an end to all of this. This is your opportunity, Your Honor. You can act in the interests of justice. And it's this almost, giving her this more moment of a calling that is really what most of his argument is resting upon. So let's go ahead and get into Lally's argument now. We'll see if we can't do the closed captioning. If we can, I'll hide my lovely face so that all of you can read that and follow along.
Your Honor, the Commonwealth would ask, request that the defendant's motion to dismiss be denied, as it was not a term. Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. If that were at any point in time indicated in any of the communications from the jury, or if there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when one, did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, case law, has repeatedly stated is the typical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries. Does quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. There's a reason for that, because there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which, following jury deliberations and defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked, that does not, the not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. Quoting from that case, and I think it's directly applicable to what's been provided to the court so far. It states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were controlled, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is a contravention to that case law in juvenile, in Bluefield, in Roth, in Gray, in all of the cases over the decades and centuries dealing with this. Bluefield itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Courtroom as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. that stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was saying, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury. And I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications.
I wanted to pause it really quickly right here because he said something I think really interesting. He talked about how the court has done nothing wrong. The court applied the law correctly. The law is correct. He's specifically talking about that verdict slip, which a lot of people have had trouble with, including myself, and that the court has done nothing wrong. Nothing's extraordinary here. This is how every case has been handled ever. Why that's important is not just so much for his argument. That's part of his argument that, you know, listen, let's not reinvent the wheel here. We've got a mistrial. Let's deal with a mistrial and move on as we would in any other of the hundreds and thousands of cases we've dealt with in this court before. But it highlights a point that I think the judge may be more concerned with than anything else. If she decides to entertain the defense motion, how is she going to do that? On what way is she going to excuse the jurors' conducts and not indicating that they were hung, other than to say there's a problem with that verdict form? I mean, and if she does say there was a problem with that verdict form, then is every single case that's ever been in that courtroom using that verdict form going to come back on appeal and say, we've got a problem too, we use that same verdict form? This isn't just about this case. This is about that form and every single case in which that form has been used. So she is very cognizant of the fact that whatever she does here today, she's going to have to do exactly what Lally just said, and that's to make sure that everybody outside of this courtroom and inside understands that they followed the law and the law is correct, and there's nothing that needs to be changed about that form. That form cannot become a problem here. That cannot become the reason for her making a decision if she decides to rule in the defense's favor. Still don't think she's going to do it, but if she does decide to rule in the defense's favor, that form cannot become the reason, because that form, she said herself, has been used hundreds of times before, and she doesn't want. That's the first thing I'd be filing if I were an attorney who had a case in that courtroom. She cannot call into question to that. So thank you, Kaylin. I just wanted to kind of point that out as the subtext to all of this.
Cases that the jury submitted to, which Commonwealth would submit, were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they have reached an impasse as far as their deliberations were concerned, as it pertains to the charges. In the final note that was submitted to the court, they refer to the charges in the plurality, twice within that note, as it pertains to exactly what they were citing. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether it's personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel had to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Cannone was asking for Arturo Rodriguez. And understanding that asking for Arturo Rodriguez is not equivalent to requesting mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, and these are Mr. Cannone's own words, on both occasions, indicated that from them, or argued for Arturo Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about exploring this trial at those particular points, or at least leading down. Now, as far, and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Counsel's request for Arturo Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to be heard on possible alternatives to mistrial. Commonwealth versus Pereira is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of the manifest necessity is a deadlock or a hung jury. And that is what we have in this case. It's clear, it's unambiguous from all the communications, even Mr. Cannone during his arguments for the Arturo Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Luper decision from the United States Supreme Court to the Supreme Judicial Court of this Commonwealth, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those how the jury stand, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when we're talking about charges with lesser included, or charges that have a multiplicity of different findings that the jury can make. Because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a hold. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe as far as not allowing the court to inquire into those types of scenarios. So, yes, the defendant's position is that the court should uphold or inquire only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive holdings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, and very deliberately, as far as the language that was used, declared themselves to be at an impasse on 2 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And that is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for an extension or creation of new law, again, sort of special or deferential treatment to this case or this defendant. The 2 areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regards to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance
That's all right. Take your time. The whole world is watching.
And in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your honor, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry.
Can you pause it, Kaylin?
The reason
I just wanted to jump in here really quick because he keeps on coming back to this same point that I've always been a little bit bothered by, that he keeps on saying that he's concentrating a lot on whether or not it's appropriate for the court to inquire into jury deliberations. And that's absolutely true. It's not appropriate for the jury or anyone to inquire into the deliberation process of a jury that is deliberating. In other words, you can't bring the jury out and for them to say that they're hung or they're out of deadlock, and for you to start saying, well, what are you guys talking about? Or what are you deadlocked on? Or, tell us what is the specific issue that's hanging you up? They can ask questions. They can ask specific questions about particular parts of the law, and you'll notice that the judge is very careful about what information to give back to them. Many times the judge will just refer them back to the instructions because the judge doesn't want to interject and get involved in that whole deliberation process. But this is a little bit different because, one, the jury's no longer deliberating, so we're not asking to get involved in the deliberative process. What is being asked is, what was your vote, folks? If you had a vote, if you had all had a meeting of the minds that this woman was acquitted of murder, by the way, the more serious charge here, we're not talking about the lesser included and some misdemeanor that was attached at the end. I know it wasn't in this case, but we're talking about the substantive charge. If you had all agreed and had a meeting of the minds that she was acquitted on that, and you simply did not know where to record that, that's not interjecting into the deliberative process. That is all that's being asked by the defense. I'm still not saying that the court has a mechanism to go about doing that, because that begs a whole lot of other questions about, do you haul 12 jurors into court once again and have them all swear and take an oath that is in fact the vote they would have made, which I think is where you would have to go if you wanted to pursue this avenue. But that is not exactly the question before the court. And so I just felt I wanted to jump in and say that that rubs me the wrong way when he keeps on going back to that issue. Thanks, Kalen.
The Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes, specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror or the juror calls you, it still does not allow the counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, in sort of condensed quote from Commonwealth versus Will. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was a product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlock jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury of their peers or retry them on the same case. That's not what's happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of this. And the court did absolutely nothing in finding a manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
Can I reply, please? Thank you. There were two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes. e.g. two separate verdicts. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus Juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser included. And that's the principle of Commonwealth v. Roth, the other case that Mr. Rowley referred to. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser includeds. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser includeds, the court prohibited such questioning as to lesser includeds. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, a court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached 2 decisions, 2 general verdicts, but we're in an impasse on a 3rd one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Sanaif case, where they've had, just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Riley's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Miss Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted a mistrial, he could have asked for a mistrial then. Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think, is a 19th century federal case, is that you have hope when you're asking for the Tui instruction. My experience, usually the prosecutor is confident in the jury that wants the Tui instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations. So it's no answer, and the Ray case does not say that when you ask for a Tui instruction, you are really asking for something more than a Tui instruction. Tui means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those 2 colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12, when she's already convinced the first 12. Thank you, Judge.
Thank you. Any responses to Lally or yours? All right, thank you very much. I'll take this under advisement.
Thanks, Judge. Judge, when I hand the Nicole case to you.
Sure, thank you.
Okay. That was fabulous. All right, you know what? Maybe we could put it. Yeah, let's put it on mute. That was great. Whoever had bet on the judge just grabbing her papers and yeeting the hell out of there, you win the door prize. That was not what I expected. I don't know why I was expecting anything different, but that was certainly not what I was expecting. I thought she would have, an end to all of this. She's probably going to issue a written ruling later on without the fanfare of the courtroom watching, but we'll continue to keep our eye on what's happening in court, but it looks like they're all done. And again, I'm fully convinced that she has already made her decision. If by nothing else, the lack of note-taking on the part of the judge, nothing that was really being said by either side was anything all that different from what was inside of what was inside of the moving papers. CJ, you are correct. It's way past everybody's lunchtime, and so it's time to get out of there. Also, it's a Friday. Can't we all put this behind us? There's the weekend to start. Pretty incredible to have everybody wait that long and then not issue a ruling. Judges do it. You would have thought in this case she'd put an end to that whole thing. But I mean, what this argument, if I could sum up both arguments in the least amount of words as possible, I would say that for the defense, it is, Your Honor, we give you permission to do the right thing. The right thing here is double jeopardy is a constitutional right. That is at play. You have evidence now that they arrived at a verdict, and we are saying that the case law and the interests of justice give you permission, Your Honor, to do the right thing. The prosecution, the Commonwealth, is saying, be afraid. Be afraid of doing anything at all, Your Honor, because there's landmines every which way you step. And if you do the wrong thing, you're going to set a really bad precedent and essentially, let things lie where they are and don't change what has already taken place here. You've declared a mistrial. Let's move on from all of that. So at end of the day, when you don't have a whole bunch of case law, I know they were citing cases and statutes and everything else, but their arguments really centered around themes. And those were the themes. It was either do the right thing or don't do anything. Those are the two resounding arguments that came out of both of these. If you guys have questions, please submit them in the comments. I'm going to try to get to as many questions as we can. But, at end of the day, we're essentially at the same place that we were before we heard any of these arguments. And that is that we're in uncharted waters, and those uncharted waters are, we now have a jury who arrived at a decision, and it might be the wrong word to call it a decision, but a mistrial is a contemplated way. A deadlock jury is a contemplated end to a trial. It is saying that there's not evidence beyond a reasonable doubt to have convinced 12 people of anything. And mistrials are declared all the time in this country, every single day. And that is the way that many times our justice system works itself out. So, that sometimes this is just what we're left with, and it may be frustrating. And now you're asking, both sides are asking, well, one side, the defense, is asking to essentially undo all of that because we have this new evidence. CJ is asking, are you saying this is truly unprecedented in the history of the legal system where one or two of the charges of the total were unanimous and it was argued as double jeopardy? Unprecedented in the history of the legal system? No, I'm not. I hope I'm getting the question right, but I mean the jurors oftentimes, when they are considering multiple charges or when they're considering lesser included charges, makes it slightly less or slightly more complicated, but they do arrive at these decisions sometimes where they do have what we call a mixed verdict, where we are unable to arrive at a decision on one thing, but we are able to arrive at a decision on another thing. And jurors or different jurisdictions rather handle that differently. In the jurisdiction where I practice, there is a rule essentially that says you cannot go from the greater to the lesser without having first acquitted of the greater. There's an instruction on that. So in this situation, the jury, if they wanted to even move on to contemplating the lesser included charges, would have had to have first acquitted Karen Reed of that greater charge of murder and recorded that. And that's important because then we wouldn't be dealing with this situation, because double jeopardy would attach to that acquittal. So she would not be, the prosecution would be precluded from retrying her on murder. This jurisdiction either operates differently, or their verdict form reflects something different than that, because that verdict form was a problem. Now, I think that this whole thing boils down to that verdict form. If you remember, Alan Jackson objected to that verdict form right before it was submitted to the jury. And he said, Your Honor, there's no way for them to indicate an acquittal on these other charges. And the judge said, yeah, they marked the acquittal box. And there was some back and forth. And Jackson, and after powwowing with Yannetti, decided, well, we want to add that language that says acquittal on all of the charges. That may have been a problem, because then it's like they can only check that box if they're acquitting on all of the charges, which in this instance, they are not, because they were deadlocked on one of the lesser included. So it wasn't appropriate for them to check that box, and it wasn't appropriately for them to check any of the boxes. But instead of asking the question, what do we do when we find ourselves in the situation where they apparently did, they just checked none of the boxes and said that we're hopelessly deadlocked. I think that verdict form is a problem. The other part of this is that the jury sent back question or notes, which were some of the more emphatic notes that I've ever seen in my career. There was no wiggle room in those notes. There wasn't any kind of equivocation on, we're really struggling back here, and could we have some guidance on what to do? It was, we have looked at everything and we are deadlocked, full stop. I don't think anyone at that point contemplated what we have in front of us now. I'm pretty sure the defense had zero idea, because they would have handled things a little bit differently. Everybody thought that we were just at a fully deadlocked jury on everything. Those two kind of perfect storm situations came together that gives us the problem that we have right now. Tisu's, who is my lovely wife, asks, Josh, you may have already answered this, but do you think the jurors will be brought in to give their verdict individually? Well, that's what the defense is asking for. He's saying, let's bring them in for voir dire. What voir dire essentially means is let's talk to them. That's what they're asking for. They're not even really asking for the judge to issue dismissals of those two charges. They're asking for the judge to complete this inquiry, because I don't think anybody really knows what to do under this situation. And they're asking the judge, haul everybody back in, Your Honor. If you feel that's what needs to be done, bring all 12 back in, swear all 12 in under oath, take a vote from all 12 on how they came back on this verdict. And if they all acquitted on the 12, then you essentially need to reopen what you did, declaring a mistrial, and then declare a mistrial only on the one lesser included, and grant her an acquittal on those other two charges, and attach double jeopardy to that to preclude the prosecution from moving forward on those two charges. Let's see. Josh, I'm curious if you touch base with AJ since trial. If so, how's he doing? Oh my God, I'm such a huge fan. Alan calls me all the time to get advice on these things. He wants to know what I would do in court. He takes notes from me on how to handle these things in court. No, I have not heard from Alan at all. And I, to be honest, am not bugging him at all either. When you're knee deep in crocodiles, it's probably the last time you want to be hearing from someone. I am sure that when the dust settles, we will touch base and have a coffee over this whole thing. But I have not touched base with him. He's got bigger fish to fry. Not to mention that, by the way, this isn't the only case he's handling. So he's likely not in court today because he's handling something else, and because it looks like there wasn't much for him to do anyways. But good question. Happy to answer it. I do not like the trend of calling jurors back. Murder of Vallow, and I think a couple others, not good. Yeah, I agree with you, tennis girl. I think there should be finality in the way that we handle these cases. I think that there has to come a point where we feel like we can finally put a case behind us and to rest. Murdoch was a little bit different in the idea that there was a claim of misconduct, and misconduct is very different than what we have here. In that case, Murdoch, they were claiming that the clerk unduly influenced them. And if that was true, then I think the court was under an obligation to get to the bottom of that. And that's why we went through that whole circus that we did in Murdoch. And agree with the judge's decision or not, she resolved the issue as far as there being misconduct. Here, there's no claim of misconduct. It's, I think, simply a claim of a misunderstanding by the jury, or the jury. I mean, let's be clear about this too. The jury filled out the form correctly. The form didn't allow for this. The form didn't allow for them to say acquittal on one count, but guilty on another count. It was just acquittal across the board or guilty on the individual counts. That's why, again, I think the verdict form is a major problem. Now, they said that they've been using that verdict form for forever in that courthouse. Again, major problem that they didn't, that they've been using it for that long, and that there might be this very obvious issue with it, unless I'm missing something here. Could the jury have compromised, not guilty on second degree if there was a guilty on manslaughter, and since that it didn't happen, the not guilty on the second is void? This comes back to, again, great question, Jimmy, that this idea of what is the instruction in that jurisdiction as far as how they have to proceed. In some jurisdictions, if they can do this kind of split the baby compromise thing, that if they're feeling like they're not getting anywhere and they're likely going to be hung on one thing, but they can all agree on something else, then they can go ahead and convict or arrive at, I mean, it would be a conviction in this hypothetical we're pursuing on a lesser included. But in this situation, it's unclear to me, even from the instructions, if they have to proceed, like I said, we do here in California, where they have to first acquit before moving on to the lesser included. And if that's not the way that it works there, it certainly wasn't explained to them that way. And it certainly isn't reflected that way in the verdict form. Continue to Jay. It's going to be a real problem with the jury, and the Young Thug trial gets called back in 2027, a few months after the trial ends. That is very true. Jay and I, it's funny, Jay and I are attached at the hip today because he and I actually recorded another podcast that I work on called True Crime News, the Sidebar, earlier today. So please check it out on Tuesday when that is released. Jay did a phenomenal job during that, and we had a really fascinating conversation, including about the Young Thug trial, which is now the longest trial in Georgia history. And they're talking about it, not even if it continues to go, not even going to end until early next year. How you're ever going to get those jurors to stick around for all of that is beyond me. Jay says it's a complete dumpster fire. I agree. It's certainly in the dumpster fire Hall of Fame for how it's being handled. And as Future points out, they've been on this long break. If I'm these people, I'm gone. I'm just not answering my phone anymore. You imagine being in this trial that has been already taken so long, then being told to go ahead and take a break for an indeterminate period of time, and then being told, oh, by the way, you need to come back, and we may go through some of the stuff we already went through before, and we've got a new judge, and please don't ask us where the old judge went. Bonnie Hassan asks, are juror forms not standard? How are they created? Who approves them? Excellent questions. They are not standard across the country. They are standard in each jurisdiction. They are standard in each state. They are created, for the most part, by a judicial council who is the same that comes out with the instructions. The instructions are, or the verdict form is almost supposed to be a mirror image of the instructions, but there's no rule saying that they have to be worded a specific way. But it's the understanding that if you don't word them a way that has already been established, you may be opening yourself up to appeal because they are so important, as we're seeing here. So I don't know if that is a form that's used in every single courthouse in that jurisdiction or throughout that state. And I'm quite frankly astonished that this hasn't become an issue before now. But maybe that's just because you haven't had jurors who've tried to contact the defense team since that time. Another interesting thing in all of this is the idea that the jurors reached out to the defense and how much was the defense allowed to speak to them. And Lawley made a big deal about, you know, again, he's trying to promote fear, fear, fear. Let's not do anything. This is going to cause a bunch of trouble. But I don't agree with him that the idea that they weren't allowed to speak with them. If they were contacted by them, these people are allowed to speak to it. These people can have book deals at this point. So the fact that they can't be questioned about what was going on is one thing. They're not allowed to be questioned about their deliberation process while they're deliberating. But after the fact, you can ask jurors. It's routine for the judges, after a verdict is rendered, invite the jurors into the hallway, and the attorneys will be out there shortly to speak to you about the case. And the attorneys are going to ask a lot of things. What did you think about this? What did you think about that? How did you guys arrive at this decision? Pamela H says, if the jurors had already come forward and start talking to the press, would have put more heat on the Commonwealth. From a PR perspective, sure. I don't think you're going to see the Commonwealth crumble on this issue. I think, again, I stand by what I said. I think the smart thing for the Commonwealth would have been to come in today and say, you know, before we get into any of this, Your Honor, we would like to dismiss the 2 counts that the jurors indicate that they were acquitting on, and we would like to set our trial for the remaining count. And can we please move on with this forthwith? Probably the smart move, not what they chose to do, which is kind of par for the course with the Commonwealth on this case. Keep the questions coming. In the meantime, I wanted to let you guys know a few short things before we end this live stream. One, we do have a brand new episode out today. Please check that out. We talk about Karen Read a little bit, if you haven't already been exhausted hearing me talk about it today. But we get into some other cases as well, including what I've now heard referred to as Suitcase Sarah Boone, and all of the wonderful nonsense that's going on in her case as well. We also, this evening, Jay and I will be doing a dual live stream on the Adelson case with Mama Adelson's trial quickly approaching. We thought it might be, thought it might be, and I agreed it would be a great idea to go into Charlie Adelson testimony from his trial and talk about what is that going to show us about her trial coming up. What might we learn from that? How might it hamstring her case? How might she have to use some of his testimony to stick them to a narrative? So please check that out. That's going to be at 6 p.m. Pacific time this evening, another live stream. I'm just going to stay in my seat to save time. And then finally, we have on Courtroom Confidential, we've been doing this series called Case Notes, where we go into cases that are in the news but are not quite to trial yet, so that you kind of get an idea of what to expect on a case that might be heading to trial a little bit later in the year. And the case we're going into today is the really awful murder of Rachel Morin. I misspoke. It's not today. It's going to be released on Tuesday. And we're going to release it as a premiere so that there's an opportunity for a live chat. So if you guys want to check that out, we will post when that's going to be released. It's going to be 6 a.m. Pacific time on Tuesday, coming up, talking about the Rachel Morin investigation. You may remember this is the awful case of a woman. She was a mother of 5 who went out on a hiking trail in Maryland and was never seen alive again. For many months, her murder went unsolved. And then what you find out is that the investigation went from Maryland to Los Angeles to down to El Salvador before they were finally able to apprehend this person. Really, really interesting case. So please make sure to check that out. In the meantime, if you guys don't already know, or hold on, Jimmy's got another question. Is Lally being cautious because Bev might call them all back and Lally doesn't want to taint them for that proceeding? Could be. I also feel that Lally realizes that it's not all that helpful for him to speak to them. It sounds like most of them, I doubt that the jurors who have come forward are just lying and going to say something that's not going to be backed up by the other jurors. And he probably just doesn't, it's not helpful for him to get into it. So, you know, why speak to them? Then he has to tell the judge that, yeah, I've spoken to them and they all say that they acquitted her, but I want you to ignore all that because it wasn't recorded, and let's move on with the trial. I'm going to try to retry her again. I mean, one of the more powerful points that the defense attorney made at the end there was she was on trial. She was acquitted by 12 people. Don't make her have to get an acquittal out of 24 people. I thought that was pretty powerful. That, you know, why are we putting her through this again? Yes, thank you, Jay. You can become a member now. That was what I was going to get into. Really special announcement for us today is that we have opened up memberships on this channel because we want to start to offer you guys more content, more exciting stuff, more merch. If you can see this on my shirt, if you can see out of my lovely cup here. So a lot of really exciting stuff to come. Please check it out, everyone. I'm going to check out, we've already received quite a few memberships today. Thank you guys. Let me just run through this list of everybody who's so far. Debbie Blair, Mijusia06, Pamela Scher, Ada Shaw JD, Ashley, Pamela H, Kai, Future, Michelle Abramson, CJ J, Laura Waldy, Yvonne McLaren, Fine Citizen, Sean F, Mia Bidu, K9 Catherine, Jody Arrington, Semi Sharp, Barb Pace Lamb, Ashley, Carly Rooks, Terry L, Jade Roscoe, Robin, and Gen X to the 7th power already signed up. You guys are wonderful. I'm waiting to, this is from Bonnie. I'm waiting for JR to narrate true crime audiobooks. Sure. Sign me up. I'm happy to sit down and read an entire book to you folks. Why not? That sounds fun to me. And to Renee, who just signed up. Thank you again. Always appreciate the support from everyone. Like I said, this was a new challenge for us today. I appreciate you guys being along with us and for the little hiccups along the way. I think this was, I had a blast. I hope you guys enjoyed it. I think we got some really interesting comments from everyone. We're going to try to be doing it much more often. And there's a first members only live stream tentatively scheduled for Saturday, August 24th, which is news to me. Thank you, T-Suze. I will put that in my calendar and I will be there. I imagine that should be important, but I think we're going to call it quits for right now because we've been sitting here for close to 2 hours and you guys have all been amazing. Thank you, thank you, thank you, thank you. When we started this whole thing, we never thought that this adventure would turn into what it has turned into, and that's all because of you guys, because of the wonderful support and feedback we've been getting from all of you. So it just makes it all the worthwhile for us to continue to try to offer you more and more perks and content and as much interactive stuff as we can do. So check out the membership. When you click on join, you'll see all the different tiers and all the different offerings under each of those. And a lot of that includes much more stuff like this right now. Thank you again. I look forward to doing this again soon. But in the meantime, I'm going to go ahead and sign off here and try to grab some lunch myself. Thank you guys again.